Right, so there was a time when we spoke about charities that we thought of bodies that were supposed to feed the hungry and defend the persecuted, look out for the most vulnerable in our society. These days, certainly in the last 10 years or so, it's all become a little bit darker. The rise of supposed charities that can help crush a protest or smear Palestinian voices, protect apartheid, and still enjoy the tax breaks whilst doing it, such as the advantage of charitable status, of course. Britain became home to the likes of UK Lawyers for Israel and the Campaign Against Antisemitism, where censorship came wearing a legal wig and political warfare to protect Israel got a gift aid receipt. But as much fun as it is to mock such entities, that's not to play these groups down because they are incredibly dangerous, and yet they're now having a taste of their own medicine, perhaps. Their masquerade may finally be cracking. You see, global civil liberties group Cage International have just published a 66-page report, Britain's Apartheid Apologists, a forensic and fearless complaint in essence, that has now triggered a formal investigation into UK LFI's charitable status. So the days of ideological lawfare hiding behind benevolence may be numbered. This story is more than just a charity investigation, though. It's about whether British law protects those who expose war crimes or those who try to silence them instead. And it's about whether charity still means public good or has become a fig leaf for apartheid apologetics and anti-democratic repression. There are charities, it seems, who are very much less than charitable, shall we say. Right, so the word charity in Britain these days has become a bit of a battlefield. Too many charities that don't feel very charitable and certainly don't seem that way in their actions. At a time when Gaza lies in ruins, when Israeli policy has been condemned as apartheid by the likes of Human Rights Watch and Amnesty International and UN Special Rapporteurs, plausibly found to be genocidal at the ICJ, how have some of the most aggressive defenders of Israel's human rights abuses managed to shield themselves behind the legal protection of charitable status? Well, it's a story that might finally get an answer because it's being asked. It's a question that's being asked as the UK Charity Commission have formally launched an investigation into the UK Lawyers for Israel Charitable Trust, the charitable arm of UK LFI, following a detailed legal complaint from Cage International. Alongside UK LFI, Cage's report also targeted the Campaign Against Antisemitism, the CAA, exposing both organisations as Britain's apartheid apologists, according to the title of this document. Entities that, according to Cage, use their charitable status not to serve public good, but to shield Israeli war crimes and silence pro-Palestinian advocacy and advance a foreign government's interests with legal impunity. The implications are enormous. Cage's complaint does more than just name and shame. It challenges the legitimacy of two registered charities, accuses them of lawfare and ideological repression, and exposes a deeper regulatory crisis in Britain's charity sector, where Muslim, Palestinian and anti-Zionist voices are over-policed, while ideological enforcers for Israel appear to operate unchecked. So to understand the significance of the complaint, let's start with who these three organisations involved are. Cage International, formed in 2003, originally as Cage Prisoners, formed to campaign for prisoners of the war on terror, George Bush, Guantanamo Bay, all of that. But it is now a broader civil liberties organisation focused on exposing structural Islamophobia and the abuse of counter-terrorism and charity law against Muslim communities. Their legal work is grounded in international human rights norms, with a growing emphasis on Palestine solidarity as a space where repression overlaps with anti-Muslim bias that they've always fought. UK Lawyers for Israel, despite the benign name, is not a neutral legal body at all. Founded in late 2010, it operates as a partisan legal advocacy group that defends Israeli government policies under the guise of legal education and engagement. Its charitable arm, now under investigation, is alleged to have supported campaigns to suppress criticism of Israel through strategic litigation, regulatory pressure, and lobbying, thereby aligning itself with the foreign policy objectives of the Israeli state. The Campaign Against Antisemitism, meanwhile, presents itself as a civil society watchdog opposing anti-Semitism. Founded in 2014, just after Israel's assault on Gaza in August of that year, great timing, guys, it's become best known for aggressively promoting the International Holocaust Remembrance Alliance IHRA definition of anti-Semitism, which equates some forms of criticism of Israel with anti-Jewish hatred. The critics argue that the CAA functions less as a neutral rights organisation and more as a political enforcer, targeting artists and academics and teachers and politicians, anybody, frankly, who expresses solidarity with Palestinians. UK charity law, as established in the Charities Act of 2011, lays out clear obligations for charities, though. Charities must serve exclusively charitable purposes, provide measurable public benefit, remain politically neutral except where advocacy directly supports charitable aims, and avoid causing harm or discrimination. The NCVO, the National Council for Voluntary Organisations, echoes these principles, stating that charities must not engage in political activity that is not incidental or connected to their legal objectives. UK LFI and CAA have, as the Cage Report and multiple media investigations allege, engaged in practices that push the boundaries of charity law. UK LFIs initiated legal complaints against NHS partnerships with groups like Medical Aid for Palestinians, submitted regulatory pressure on universities hosting events related to Palestine, and challenged the funding of charities that advocate for Palestinian rights. While not always successful, these actions reflect a strategy of using legal instruments to advance highly partisan political objectives under the cover of charitable activity. UK LFI has launched legal complaints to prevent NHS partnerships with groups like Medical Aid for Palestinians, lobbied universities to cancel educational events related to Palestine, tried to defund charities that advocate for Palestinian rights. They're not actions that serve public education. They're ideological campaigns aligned with Israeli state interests, operating through the mechanisms of lawfare. The CAA is similarly allegedly overstepped its bounds, though high-profile campaigns against political figures such as Jeremy Corbyn, extensive promotion of the IHRA definition, the organisation has contributed to an environment in which criticism of Israeli state policy is frequently reframed as anti-Semitic. This is not neutral anti-racism advocacy, it is ideological suppression. Moreover, such behaviour clearly breaches the requirement to provide public benefit without causing harm or engaging in politically partisan behaviour. In fact, Cage made a very salient point regarding the IHRA definition, which is well worth highlighting. Contrary to the examples of what the IHRA definition considers to be anti-Semitic posts in relation to Israel, Chamberlain clarifies that those examples existed within a certain context, albeit highly contested, but in other contexts could not be relied on. What the judgment clarifies is that Article 10 of the Human Rights Act of 1998 protects the following speech and cannot be considered inherently anti-Semitic. Calling for the abolition of Israel and its replacement with a unitary state comprising Jewish and Palestinian citizens, highlighting the ethnic cleansing of the Nakba upon which Israel was constructed, claiming that the existence of a state of Israel is a racist endeavour, describing Israel as an apartheid one, comparing Israel with Nazi Germany even if incendiary and especially hurtful, unless used as a racialised taunt. Rather interesting given a lot of what we see on social media, isn't it? The concept of lawfare, central to Cage's report, describes the deliberate misuse of legal systems to undermine human rights, silence dissent, and enforce political conformity. UK LFI and CAA have both deployed lawfare to devastating effect. By weaponising complaints and exploiting institutional fear of reputational damage, they've effectively silenced debate. These tactics have had real-world consequences. For instance, UK LFI submitted a Freedom of Information request and lobbied NHS trusts in an attempt to pressure them into severing ties with Medical Aid for Palestinians, as aforementioned, raising alarmist claims about extremism. And whilst these attempts have not been confirmed as successful in achieving their goals, they reflect a broader strategy of regulatory harassment and reputational damage using false claims of extremism. Meanwhile, Palestine solidarity events at British universities have been targeted too. One striking example occurred at the University of Essex in 2017 when UK LFI sent a legal warning to university officials suggesting that a planned panel discussion featuring Palestinian academics could breach anti-terror laws, violating the prevent duty, as they had put it. And while the university ultimately allowed the event to proceed after review, the intervention created a chilling effect and exemplified how legal intimidation can deter institutions from engaging with Palestinian perspectives. CAA's lawfare tactics have contributed to a climate where criticism of Israeli policy is frequently framed as anti-Semitic. Its promotion of the IHRA definition, how they choose to interpret it, and public campaigning has helped normalise the conflation of political dissent with hate speech. This contributes to a broader culture of caution and suppression within public institutions. There have been wider concerns that the politicised application of the IHRA definition has led to disproportionate scrutiny of educational discussions around Palestine. The Charity Commission's current investigation into UK LFI arrives after years in which equally contentious alleged misconduct from Muslim-led charities was met not with leniency at all, but with institutional overreach instead. Interpal, for example, endured 3 separate Charity Commission inquiries in 1996, 2003 and 2006 through to 2009, all ending in clearance, but they still lost bank access and reputation. Similarly, Islamic Relief was subjected to smear campaigns linking to the state influence and bank de-risking, later vindicated by an audit. And Cage itself, actually, while ultimately cleared as well, saw major funding withdrawn amid regulatory pressure. The disproportionate scrutiny of these Muslim charities, despite repeated exoneration, stands in stark contrast to the delayed action against UK LFI. This two-tier approach reinforces what Cage calls institutional Islamophobia, the view that Muslim-led civil society is inherently suspect, while Zionist-led repression is institutionally protected. CAA's own history with the Charity Commission further exposes this double standard. A complaint submitted in 2019 by Jewish Voice for Labour regarding CAA's overtly political campaigning was dismissed in 2024 after a prolonged and toothless inquiry. Meanwhile, CAA continued to publish highly politicised statements, such as condemning UK government policy on arms exports to Israel that critics argue crossed the boundary of political advocacy and should have triggered regulatory scrutiny. The regulator's silence on these violations, or alleged violations, undermines the credibility of charity law and public confidence in oversight. But perhaps the most damning charge in Cage's report is that both UK LFI and CAA are complicit in defending apartheid, ethnic cleansing and genocide. And this is not rhetorical hyperbole, it reflects mounting international legal consensus. The International Court of Justice's 2024 advisory opinion labelled Israel's occupation regime a system of racial segregation and apartheid, in breach of Article 3 of the International Convention on the Elimination of All Forms of Racial Discrimination. Bodies such as UN experts, Human Rights Watch, Amnesty International, Israeli NGOs themselves like B'Tselem have all articulated similar findings. UK LFI is documented as actively undermining these legal frameworks, including efforts to delegitimise the work of UN special rapporteurs such as Francesca Albanese, and to challenge the International Criminal Court's authority over Israeli war crimes. Similarly, the CAA routinely portrays references to apartheid or genocide as anti-Semitic slander, thereby conflating legitimate legal criticism with hate speech and chilling discourse around Israel's human rights violations. The cumulative effect of UK LFI and CAA's actions has been to contribute to an erosion of civil liberties in areas related to Palestinian advocacy. While direct causality is difficult to prove in specific cases, cultural organisations have reportedly avoided programming on Palestine due to fear of reputational damage or legal reprisal. Student societies have also described increased self-censorship. These developments reflect the chilling effect of lawfare-driven intimidation, even where no formal sanctions have occurred. The right to support Palestinian self-determination, oppose Israeli apartheid, or engage in boycott activism is increasingly under attack. Cultural organisations avoid programming on Palestine. Look at the BBC as a classic example of that, and the programming that they've refused to show. Students face disciplinary hearings. Academics and cultural figures have faced heightened scrutiny when addressing issues related to Palestine. Although claims of blacklisting or formal disciplinary actions require careful substantiation, the broader atmosphere has discouraged many from engaging with the topic publicly. This culture of fear is deliberate. UK LFI and CAA are part of that. They do not merely respond to alleged instances of hate speech, they seek to proactively deter expression as well. This chilling effect corrodes not only public discourse, but the very foundation of democratic participation. It is particularly galling that Jewish anti-Zionist voices, such as those from Independent Jewish Voices or Jewish Voice for Labour, are also excluded. They are silenced not despite their Jewish identity, but because their dissent undermines the manufactured consensus that equates Judaism with Zionism. This erasure of internal dissent within the Jewish community is a hallmark of ideological enforcement, not anti-racism at all. Cage's report calls for decisive action. UK LFI and CAA must be deregistered unless they can prove full compliance with charity law, including the public benefit test and neutrality requirements. The Charity Commission should commission an independent review of its own practices, particularly its record of bias against Muslim charities. Legal reforms are needed to prohibit any charity from aligning with the interests of a foreign government known to be engaged in crimes against humanity. There must also be formal protection for political expression, including support for Palestinian liberation within educational and charitable spaces. Furthermore, the adoption of the IHRA definition should be reversed. It is a politically compromised tool used to police dissent, not to protect Jews from racism. We need something better. It must be replaced by a definition that distinguishes between anti-Semitism and legitimate political criticism, and in no way can be conflating of the two. Charities defending apartheid, wherever it occurs, whoever they are, must be treated as violations of public trust. That includes pro-Israel groups operating in Britain under the guise of neutrality. The investigation into UK LFI and the case made against CAA as laid out by Cage must be seen as more than isolated complaints. They are a window into a deeper crisis, a legal and regulatory system that protects power over justice, censorship over freedom, and apartheid over equality. Cage's complaint has exposed the structural enablers of repression and challenged the ideological masquerade of charitable lawfare. The Charity Commission has a choice before it, therefore. It can enforce the law equally. It can uphold the principles of charity that it is supposed to do. It can defend civil liberties. Or it can continue to legitimise lawfare, censorship, and complicity in international crimes. All of this, of course, is set against the backdrop of Starmer's pledge to recognise a Palestinian state right now, but only conditionally upon Israel doing what he wants them to do, by an arbitrary measure, by his own viewpoint, come September. Already there are signs he might be walking back on this pledge, or at least having the door opened for him to do so, once more as a result of lawfare. So check out that story here as your recommended next watch. Please do also hit like, share, and subscribe if you haven't done so already, so as to ensure you don't miss out on all new daily content, sort of spreading the word and helping to support the channel at the same time, which is very much appreciated, holding power to account for ordinary working class people. I'll hopefully catch you on the next vid. Cheers, folks.